But to this, former President Jacob Zuma will find out today if his 15-month jail term will be set aside. The Constitutional Court is expected to deliver judgment. This after former President Zuma had asked to rescind the sentence. Now, the former president is on medical parole at this point, and he was found guilty of contempt of court over his refusal to appear before the Zondo Commission. Let's take this discussion even further. This morning, I'm joined by legal expert, Mr. Benedict Phiri, who joins me to take this discussion forward. Thank you for your time, Mr. Phiri, and good morning to you. I want to pose this question to you, which was a tweet posted just last night, by the Concord here. Is the judgment and order of the Constitutional Court sentencing former President Zuma to imprisonment for contempt of court rescindable, and can it be set aside? I think that's the question on everyone's lips here. Your perspective.
Yeah, thank you so much. My view is that in this instance, we're not going to have a rescindable order and one that can be set aside. And if you just pause for a moment and just go back to what Jacob Zuma has asked the court to do, he's asked him to go back on his decision to find him in contempt, number one, and number two, go back on his decision to send him to prison for 15 months. Now, he is in contempt, and he's actually admitted that in his papers in not so many words. The question then is, what do you do with the contempt? And he's saying, well, you shouldn't have sent me to prison directly because this is a fundamental encroachment into my rights to have a fair trial and to have the right to appeal a judgment which is put for accused persons, which I think is actually not very persuasive. And I say that because, the rights to a fair trial within the context of contempt proceedings have been debated at length by the Constitutional Court, the Supreme Court of Appeal, and other courts in the country. And then the question around whether he's entitled to a fair trial, within a criminal context before being sent to court, I think really the outcome of that, what he's asking the Constitutional Court to do, is set a precedent which could be dangerous for the administration of justice in this country. Because ultimately, you have a person who's sued, who decides voluntarily, for his reasons, not to participate in the process, scandalizing the court within, in that process, and thereafter gets ordered to do something, decides that he won't do something, and when he's now being sent to court, to jail for defying that order, he makes arguments after the fact. I think that is a problem for the administration of justice in this country, and I don't think the Constitutional Court would want to set that precedent.
Let's just get then some law 411 here context for those who are not law experts as yourself, Mr. Phiri. Just in terms of an order of the Constitutional Court being granted, can it be appealed?
An order of the Constitutional Court can't be appealed. And this is part of Jacob Zuma's complaint. He's saying the commission shouldn't have come to the Constitutional Court first. They should have gone to the High Court so that I can appeal this all the way up to the Constitutional Court. But he misses the argument because that argument is about direct access to the Constitutional Court. And once a Constitutional Court grants you direct access, it's not appealable. It's final. And you live with the consequences, especially where he decided he wasn't going to participate in the process and make arguments to the court.
So with that being said, then, what does Rule 42 say about the courts and such decisions in this particular case where we're looking at former President Jacob Zuma's, case?
Rule 42 is the entry to rescission. And it says essentially that there are three requirements that a party that seeks to rescind a judgment must meet. The first is that an order must be granted in the absence of that party, and it must have an error in it. The second is that you can rescind an order if it is, is subject to ambiguity or something of that matter. And the third is that, there could be good cause shown to rescind the order. So now if we take the first two, Jacob Zuma cannot be said to be absent in these proceedings because he did decide not to participate. That would have been applicable if a party was not given notice to the proceedings. Over and above that, the error is not a patent error in the sense that the fact that there's a disagreement between the majority of the Constitutional Court and the minority of the Constitutional Court doesn't mean the judgment is wrong. The Constitutional Court made the right judgment based on all the information they had. The fact that there's a disagreement just means that Jacob Zuma prefers the disagreement, or rather the minority judgment. And then if we go to good cause, I've just explained reasons about the administration of justice, which I think for me are going to be more persuasive than the reasons that President Zuma has put up, his health, the fact that his lawyers gave him bad advice at the time, etc. And then we can then talk about the ambiguity. There's no ambiguity in the judgment. It's very clear. There's nothing that needs to be corrected, which, for instance, doesn't flow from the reasons of the judgment and the order. So I think, within a Rule 42 context, I think it's really going to be a tough ask from him.
Yeah, well, we appreciate that context. Given 10 a.m. this morning, that will give more perspective as to what we can expect, of course, from that judgment. Thank you so much, Mr. Benedict Phiri, law expert, just, of course, talking to us there ahead of that judgment by the Constitutional Court come this morning, and stay tuned to eNCA for all those developments.